Right, I'm going to give you the worst 45 minutes of your lives. It is depressing. It's bloody boring. I would get on the phone to the Samaritans now, because they tend to get busy by the time I've finished my talk. As I say, it's the single most boring subject on the planet. What can I say? If I say something remotely funny, please laugh. Because last time I spoke to this many people, no one laughed. It ruined the whole funeral. Right, a little bit about us. This is who we are. Okay, we are the property franchise group, which incorporates all these brands you can see. Did anyone realise that we were that large? It's good, isn't it? So country properties are one of the jewels in our crown. I think I quoted you properly. But we've got Belvoir, Hunters, Martin & Co., CJ Hole, Parkers, Mullocks. So we're an enormous business. And the reason I'm telling you this isn't for us to show off. It's just to say we manage 155,000 properties. So we can't afford to screw this up, all right, because we're going to get sued badly. Right, let's see who the educated people are in this room. Does anyone know who that is and what it is? Brilliant, Pandora's box. And do you remember what was in Pandora's box? Yeah, she was in Pandora's box. I had to change that picture. It was Michael Gove, but it's changed. So when Pandora's box was opened, all the evils of the world escaped, and all that was left was hope. And that's kind of where we are at the moment. Now, I'm going to tell you all the bad stuff. I'm going to tell you some of Eric's top tips on how to get around parts of the legislation lawfully, or rather show you how not to get caught. And then I will tell you what the solution to it all is. And one thing it isn't is to sell your property. You'd be mad at the moment because there's a dwindling number of properties, which means rents are going up, which means you lot are going to get better off. Does anyone know who this is? It's a lady called Polly Neat, and she's part of Shelter. Now, a lot of people will Google things about Renters' Rights Bill. Don't. You will get the wrong answer, because Google gives you the most frequently asked questions, and the way algorithms work, it isn't always the most relevant answer, because if something changes today, it won't appear on Google for ages. So do not Google the Renters' Rights Bill. Listen to people who actually know what they're talking about. And what you will find is most people have got it wrong. Most agents have got it wrong. And many agents are ignorant to it. I went into a local agent where I live and said, hi, what do you think about the Renters' Rights Bill? Oh, it'll never happen. It bloody well will. It's steaming along. The only reason it isn't law now is because of people like Donald Trump, tariffs, wars. That's what's holding it up. But it is ready to go. And I can pretty much guarantee I know 98% of it. So what qualifies me as a fat, enthusiastic amateur? Are there any lawyers in here? Good. I hate lawyers. If they were always right, you wouldn't need two in an argument, would you? I dealt with a lawyer a couple of weeks ago who actually instructed us on 10 properties. I said, what sort of lawyer are you? Are you a property lawyer? He said, no, I'm a criminal lawyer. I said, aren't you all? So I'm a member of the Lettings Industry Council, which is a far-reaching organisation. I'm on the Lettings Advisory Board, which is kindly organised by Zoopla. I'm chair of the Property Redress Scheme, Ministry of Housing, Communities and Local Government Advisory Panel, and I'm the Trading Standards Panel member, though I don't think I will be for long after my last interaction with them. So, is anyone here worried about the Renters' Rights Bill? Good. Nice to see some honest people. Are you worried about the abolition of Section 21?
Yes.
Okay, why?
Because if I want to get rid of my tenants and sell my property, I want to be able to carry on serving Section 21s.
All right, well, good luck with that, because you won't be able to. It's going. There's no doubt about it. but it won't affect your plans, as you will see. Why do I know this? Because in 2017, the legislation changed in Scotland, the land of heather and permafrost, and it didn't make a blind bit of difference. You can still get your property back, and we'll go through that unless you own it as a limited company, in which case it gets a bit more complicated. So no more Section 21 notices, the erroneously called no-fault evictions. The only thing that may affect is antisocial behaviour, but we'll cover that. No more fixed-term tenancies. They will cease to exist. All tenancies will be for life. Okay? So no fixed terms. Even if a tenant wants a fixed term, they can't have one. It's ridiculous, but I'm afraid that's what this great electorate voted for. If you do anything wrong, you'll get fined. Fines are from £7,000 to £40,000, plus rent repayment orders, which have changed from 12 months repaying the rent to the tenant to 24 months. Now, we can protect you from all this, as you will find out. By the way, if anyone has any pressing questions that they can't wait till the end to ask, just stick your hand up and ask me.
What was Section 21, sorry?
Sorry? Oh, I'm sorry, I should have said. It's notice the landlord requires possession of a property. So you can serve it without having any reason to do so and ask the tenant to leave.
How did they get round to you?
What a brilliant question, thank you. I'm not telling you. We will come to that. Have you been peeking at my slides? So one of the benefits of Section 21, has anyone ever used Section 21? Okay, did it ever go to court? If it goes to court, it's bloody difficult because the judge looks for any reason to dismiss it. And those are all the things that the judge will expect to see. Now, I don't expect the people at the back to see that, but if you want to know what it is, look at Form N5B, page 20, and it lists all the things you have to provide to a judge. And there are some things that you really can't remedy. With Section 8 notices going forward, none of this applies apart from deposit protection. Does that make sense? There are restrictions. So, if a lease says, your head lease, anyone got a leasehold property? Yeah, all right. If it says you only have to have ASTs, ignore it. There won't be any ASTs, you can't have them. And if you create an AST, you get a £7,000 fine. Mortgages cannot specify it has to be in a short hold tenancy, which most mortgage offers say at the moment. No more. They can't do that. Anywhere that it says that at the end of the tenancy must be handed back with vacant possession will no longer apply. Does anyone use any rent-to-rent companies? Good, don't. Anyone who offers guaranteed rent where they become your tenant and then sublet it, don't touch it with a barge pole because they can't get around it. These are the bits that are going to upset you a little bit. You can only take a maximum of 1 month's rent in advance. Did you know that? So going back to your student question, madam, you can't take 12 months rent in advance. It gets worse. You are allowed shorter periods, but not longer. So you can only take 1 month's rent in advance after the tenancy agreement is executed. Which means if the tenant doesn't pay the 1 month's rent and they've executed the agreement, you can't stop them moving in. I'm serious. It would be a breach of Schedule 1 of the Protection from Eviction Act 1977. We can solve that. We have a mechanism in place. Whether it survives any court challenge is another story. But we do have other solutions as well, so we can protect you against it. But the law as it's written means that once it's executed, the tenant can move in regardless. So they could actually move in being a month in arrears. Scary, isn't it?
Can I So if you've got an existing AST and it's just on a rolling month, so it's initial 6 months, rolling month, are they got to be all reworked,
No.
renters, or do they carry on?
They'll carry on.
The tenant can
But
come back and say, I want a new non-existent agreement.
Yeah, but it won't be a 12-month tenancy. All right? It'll be a rolling tenancy. All tenancies will become...
No, existing ones with existing tenants don't have to be reworked.
No, but we'll come on to what you do have to do, but it's not something I'd concern myself with at the moment. If you've already taken rent in advance before the bill is enacted, you won't have to give it back. Okay, there's a lot of things that you won't have to do. For example, if you issue a Section 21 before the bill comes in, that Section 21 will remain valid for its lifetime, which is 6 months. Okay? It's only when the bill is enacted, all these things will change. So tenant notice going forward will be 2 months. How much notice does a tenant have to give at the moment to end a fixed-term tenancy? None. None. I love this phrase and I won't be able to use it anymore. It expires with the natural effluxion of time. Isn't that lovely? But going forward, a tenant must give you 2 months' notice. So they could move in on day one and give you 2 months' notice, which will end at the end of the 3rd month because common law suggests it must be in line with the rental period. Does that make sense? So if they give 2 months' notice, it won't take effect at the beginning of the next rental period and then 2 months, but they've been there a month, so you'll get 3 months. This is interesting. You cannot specify the means of notice. They can text you, they can WhatsApp you, they can put it on Facebook, as long as it's written. But you can specify to whom it is served, either the landlord, the agent, whoever, the relative, it doesn't matter, but you can specify to whom it's served. Now, this is a good bit. This is one of Eric's top tips. Notice from one tenant is binding on all. So if you've got 3 or 4 tenants in the property, look for the one who's the poorest, offer them £1,000 and tell them to give notice and bugger off. All right? How's that for a great idea? Problem solved. I told you they're not, this is being videoed, but not for the lawyers. You will only be able to obtain possession of your property using Section 8 grounds. Is anyone familiar with Section 8? It's normally for breaches of contract, okay? But Section 8 will be your only way forward. Most notice periods have lengthened, they've doubled. All no fault grounds are now going to be 4 months instead of at the moment 2. 4 weeks notice if they're in rent arrears. How much rent arrears do they have to be in before you can take action? Who said 3? Have you been reading my slides as well? At the moment, it's 2 months, but you're absolutely right. ASB will change as well. It's a bit of a difficult one, ASB. That's where we used to like Section 21 because it's easy, but now you'll have to prove your case, which generally means getting a neighbour to grass them up. I worked in East London for years. Not a good idea. So rent arrears, you have to give a month's notice effectively. Grounds 10 and 11. Ground 10 is where the tenant was in arrears at the time you served notice, and ground 11 is that they were regularly in arrears. But ground 8 has been extended. They now have to be 3 months in arrears before you can serve them a month's notice, which means it'll be 4 months before you can start legal proceedings to get possession. And guess how long it takes to get a court date? Another 6 months, probably. So you're going to have a year's arrears. Hey, that rhymes. You're going to have a year's arrears before you get possession. We have a solution to that as well. Are there any people who manage their own properties? Yeah, out. We'll see if you still want to at the end of this. There was a plan that if someone was in arrears 3 times in a 3-year period, that they would lose the property. That's been ditched. That was one of the good ideas Michael Gove had. So it's going to be 4 months of arrears before you can start court proceedings. You're probably looking at 8 months to a year to get your property back. And it's very unlikely tenants are going to pay you money. Any questions on rent arrears? God, look at all those happy faces.
Can we pay for a private hearing with the courts?
No. It has to be through the prescribed method of Section 8. Now, this is what you were talking about selling. So, ground one, and forgive me if I go a little bit J.K. Rowling in a minute. Ground one is you want to let the property to a close family member. You can do that, and the government have very kindly listed what a close family member is, in case you didn't know. But they've actually included in that the term half-blood. It doesn't mention princes, but it does say half-blood can be a close family member. There's a caveat to this and the next one. The tenant is entitled to have lived in the property for a year before you ask them to leave. Well, that's not strictly true. They're entitled to 12 months in the property. What that means is you can serve notice at 8 months, giving them 4 months notice so they leave after a year. If they've already been in the property for 6 months before the bill is enacted, that 6 months counts towards that year. So it's not all doom and gloom. If you wish to sell your property, you serve ground 1A, which is fine. However, there's a slight fly in the ointment. The property cannot be relet for a period of 12 months. There's a moratorium of 1 year after expiry of the notice before you can relet the property. Does that make sense? So, I am not Angela Rayner.
Why? You sold it.
Yep.
I sold it to you. Does that mean that you can't?
No. In fact, if I was the buyer, you could even let it to me while the sale's proceeding. So, 12 months. So here's my top tip on this. Don't serve the notice. Go around to the tenant and say, listen, I want to sell the property because I've got a few difficult issues. Rather than me serve you a 4 month notice, how about you bugger off and I give you a couple of £1,000? All right? That would be fine because the moratorium only starts with the expiry of the notice. Does that make sense? It's what we call cash for keys. And that will be perfectly acceptable because the key litmus test will be the expiry of the notice. If you don't serve one, then you're not bound by those rules. Does that sound a bit more encouraging?
I'll just ask the question in new ground one. Will you have to provide evidence letting to a close family?
The honest answer to that is no, but if it's seen to be advertised for letting, they will spot it. The local housing authority are going to be all over this for reasons you'll find out. And I wouldn't recommend it because that's £7,000 fine, immediately possible rent repayment order. If the tenant, who's the biggest police force in the world, sees it advertised on Google while they're looking for a new property or see it on Rightmove, you're going to be in hot water. I've got to watch that one. So, as we said, 12-month minimum occupation period from the start of the tenancy until the notice expiry. Again, you have to give 4 months notice you want the property back. Penalties as usual. And the restricted period, the moratorium, starts with the expiry of the notice. So as I say, don't serve one. Bring them some cash and tell them to go. Does that all make sense to you? Please say if it doesn't. Yes, sir.
Is there any involvement of the court in 1 and 1A?
Yes, because it'll be a Section 8 ground 1 and 1A. And if they don't comply with it, you'd have to go to the court.
So 1A still have to go to the court?
No, not if they comply with it. Only if they don't. That's the first time I've been asked that. Thank you. I don't often say that. Rent increases. Up until now, you only serve a Section 13 notice in a statutory periodic tenancy. No other time do you do it. In fact, you'll be thrown out. Going forward, you'll have to use a Section 13 notice. It's Form 4A on the government website. and it's a prescribed form. There is no way around it. Another top tip, don't negotiate with your tenant. You put on the Section 13 notice the new market rent. Let's say it's another 500 quid. If your tenant phones you up after you've served it and says, I can't afford that, will you do it for 300? You can say yes. But if you agree the 300 with the tenant before you serve the notice with 300, they can still appeal it. Does that all make sense? There is no permissible agreement until you've gone through the process or the first tier tribunal have made a determination. It will take you 6-7 months to get to a tribunal hearing. Now, one thing most landlords think is, if it is free to appeal, does every tenant appeal? They don't. Most tenants, honestly, can't be bothered to fill out all the forms. So in Scotland, they don't. Some do, some don't. But we can serve the Section 13 for you to make sure it's correct, and we can represent you at the tribunal hearing. So again, it's not the end of the world. What has changed is, as it stands, a tribunal can award more than the amount on the notice. Going forward, they won't. And the next date that you can renew or review your rent will be the anniversary of the tribunal hearing, not the anniversary of the tenancy. So the tribunal sets the new rental payment. They can also add on a couple of months if they think the tenant's being hard done by. Seriously. This is not rent control, but it is rent suppression. The government surprisingly said they didn't believe in rent controls. And if you look at the famous Swedish economist, whose name I can't remember, who said the best way to destroy a city other than bombing is rent controls. In Scotland, we had rent controls. And guess what? Rents went up more in Scotland than anywhere else in the country. Why? Well, because they were suppressed a little bit. As soon as the tenant moved out, they were whacked up massive. Student tenancies.
Is there a minimum rental increase
No.
like 5%? So you
No.
can whack 15?
They are talking, it's a really good question actually, because there has been talk of it, whether it should be the Consumer Prices Index, but no. It'll be to market rent as it stands. Okay? So you can put it up what you like, as long as you can prove it is the market rent. But we're going to talk about that a little bit more shortly. So student tenancies were exempted from the previous Renters Reform Bill. They're no longer exempted. There's a new ground 4A where you can get notice of your property on a mandatory ground, provided the notice expires between June the 1st and September the 30th. And this ground 4A can only be used in tenancies which are signed no more than 6 months before the commencement date, and it only applies to HMOs. So if you've got boyfriend, girlfriend in a property and they're students full-time, you can't get them out. It's only in houses of multiple occupation. Is that clear? Going back to your good question, we won't be required to replace the tenancy agreement. All right, we will do in time, but initially we won't. It's just that any term in there which contradicts the Renters' Rights Bill will cease to exist because statute overrides contract. What you will have to do is provide what's called written terms. Now, we don't know what those are yet. We suspect we do, which will be an explanation of what the tenancy agreement means, which is what I call a tenancy agreement. But hey, in Wales, are there any Welsh people here? Oh, good. In Wales, they produced this, what they call their model written terms. So we thought, good, they've done our job for us. The day before it became law, they said, by the way, you can't use the model version. It has to be specific to your own tenancy agreement. So I had a very late night that night rewriting it. This must be served before the tenancy starts, but if it's already started, it must be served within a month. Okay? Does that make sense? Civil penalties, I'm not going to list them again. And of course, rent repayment orders. And again, if you're being managed professionally, we will do all this for you. If you're not and you're self-managing, you will have to do this. And if you get it wrong, big fines. Has anyone heard about the ban on rent bidding? Oh, you'll love this. You'll absolutely love this. I had to change the original word to nonsense. I change it back when I'm training staff, but for you it says nonsense. All adverts must specify the rent, which we've had to do by law since 2008 under the Consumer Protection Regulations. It's just rubbish. However, you won't be able to take a penny more than the rent advertised. So, as you're a bunch of landlords, what do you think rents are going to do? Has people not thought this through? No offer above this amount can be invited or accepted. So, let me ask you a question. As an agent, well, I'm not an agent, but if I were, by law, I have to put forward every offer I receive. So you've got a property on the market for £1,000, right? And some tenant says, actually, I really want that place. I'll offer you 1,100. By law, I've got to tell you I've got an offer of 1,100, but that you can't accept it. Does anyone remember Bullseye? Look at what you could have won.
Yeah.
Same financial penalties. And who's responsible for overbidding? It's the bloody tenants. It's not us. We don't say to people, well, we've got this property for £1,000. We want you to pay 1,100. We don't do that. It's not economically viable. We want to do what's right. But this is what's going to happen. Any views on that?
This is going to cause more corruption. Because if somebody wants a flat, they'll just pay something on the table for the landlord.
Yeah, it's nice to know your mind.
Yeah, so how do you stand then this flat that's worth £1,000 a month, I'll put it on the market for 1,200. You come along and say, well, no, it's fixed, we'll give you 1,000.
It's up to you.
Reduce it.
You can reduce it, but you can't go up.
So I've got a high price on the bill.
This is my problem. I mean, I've got offices in Chelsea, Knightsbridge, that are thinking of putting like £3,000 a week onto their rents. I think it's criminal, but government seems to think, oh, don't worry, it'll all settle down.
Or 5 offers of the same rent. How are you allowed to choose which one? Are there all sorts?
Actually, that's a really clever question. You choose the one that's best for you, as long as it doesn't, because one of them's on benefits, we've got dogs or children, or they're Welsh. Actually, I think the Welsh one's in the legislation. That's perfectly acceptable. Anyone worried about pets in lets? Yeah. All right, give me a reason.
Rats smell.
Really cold.
You just had to move carpets throughout one of our.
Who paid for that?
We did because we look after our tenants.
Okay, that's fine. I'm going to tell you how to deal with pets in lets.
I'm concerned saying, yes, Mr. Tenant, you can have a pet. And their pet idea of pets is 6 pets running around.
Okay. Well, I'm going to give you some practical advice. Poison. You can advertise a property as unsuitable for pets. So if you've got a little flat and someone wants a Rottweiler, you're perfectly within your rights to say no. All right? That's fine. And it's rather the same with children. If I had a small cottage with a short garden and a fast-flowing stream at the end, would I feel good renting to toddlers? No, I wouldn't. In fact, I am morally obliged to tell people it's dangerous for children. Same with dogs. You can say no. What the law actually says is that you must consider their request. It doesn't say they're allowed a pet. However, somebody like my daughter who's just rented a property, she's got a very well-behaved, lovely Cocker Spaniel, She was honest. And the landlord said, well, as long as you take out pet damage insurance, that's fine. There's your carpet problem solved. Does that make sense? What you don't want is a situation where you grant the tenancy, a nice couple move in and bring in their Rottweiler. That's the bad side, because there's nothing you can really do about it. Yes, you can issue a Section 8 notice of breach of contract, but it won't get you anywhere. So it's much better to be upfront with people, get them on side and make them pay for the rent, the insurance. Now, don't ask them to pay for it themselves, because they'll just move in and cancel it. You pay for it and pass on the cost.
What happens if in your lease it says no?
You've been at my slides as well.
Oh.
It's reasonable to refuse if the superior landlord, what brilliant timing, says they can't have pets, because that lease is outside the 1988 Housing Act, so it's binding. So if your superior leaseholder or the freeholder says no pets, there's a perfectly good reason. Can anyone think of any other good reasons not to have pets?
Dogs in a house that's next to sheep in the field and an eel or whatever.
Well, I've never heard that before, but yes, that would be fine. That would be fine, because it's a good reason. One of the other ones I would suggest you all rely on is allergies. Now, this isn't a joke, it's true. I had anaphylactic shock twice because of a cat. And my evil ex-wife, Voldemort, had a cat. And I'm convinced she used to put it on my pillow when I was out. And I ended up ambulance twice.
So, is there a definition of pets?
No.
You could say an alligator's a pet.
You could? No, there's no definition. I mean, if there were a definition, would a goldfish present a problem to anyone? No. It's just about having a good reason. All right? I don't think it's going to be a problem. Yes, madam?
What about annoyances to neighbours?
That could well be a good reason. I mean, the truth is, there isn't a list of good reasons. They will all be tested. But I think that would be a very good reason to say, look, these properties aren't that well soundproof, and a barking dog would upset the old lady next door, who happens to be old but not deaf. All right?
Can you have a TFA against the point 2 there? So subject to TFA insurance.
Yes, because that would be grounds to refuse. So that would be absolutely fine.
No, but it says there you can't unreasonably withheld the request for a pet. And it's granted number 2.
Oh, sorry, TFA. That refers to the Tenant Fees Act.
Sorry, can you have that not unreasonably withheld, subject to?
Yeah, you could put it in there, but you wouldn't need to, because it's down to you to accept or decline. But the TFA reference is actually because of the 2019 Tenant Fees Act says you can't force a tenant to pay any fee. And that's going to be amended to allow you to pay for pet insurance.
If my tenants moved in and the landlord's got pet insurance for them, then obviously there's no fixed terms. So my tenants move out, I don't know, at month 4, but the insurance my landlord's taken out for the whole year. So would you ask the tenants to pay for the whole year?
Oh, yeah. Bloody right. Now, I don't know if you know this, but each and every one of you is going to have to join their own landlord ombudsman, landlord redress scheme. Are you aware of that? So at the moment, unhappy people, including unhappy landlords, tenants, sellers, buyers, can make a complaint to the property ombudsman. Going forward, you will have to be a member of a landlord's ombudsman. And if you have a property in your name, your wife's name, joint names, and a limited company, you'll have to do it 4 times. And I asked government, who are a hilarious bunch of people, who should the tenant complain to, the agent's ombudsman or the landlord's ombudsman? And their reply was, well, I'm sure they will work together. Yeah, like hell.
So he's regional then, are these ombudsman?
No, it's a national ombudsman. It's going to be the housing ombudsman, who are slower than an asthmatic place, yeah. You'll have to have membership before we can market or you can market a property. And if you haven't, the same penalties will apply. There could be more than one scheme, but I'm pretty sure there won't be. And they will charge for it, you're quite right.
So if you've got existing tenants, you don't have to join an ombudsman.
Only when you remarket.
Right. So long-term tenants, you don't need to pay half.
No. They haven't been very clear on that point. They may require it, but they haven't published the regulations and guidance yet. They have a power to expel you from being a landlord. Yeah. And you'll also have to join the PRS database. So on the PRS database, we don't know what it looks like. I mean, I've seen the draft of it and can confidently, professionally say it's crap. But what you'll have on there will be your EPC, your gas safety record, Legionella's risk assessment, EICR, forgive my hesitation, but it's an anagram of Eric and it's really hard to do. You'll have to have a unique identifier before you can advertise the property. Again, there'll be fees for operation, but we can do the database bit for you.
If your property is fully managed, how much do the landlords have to do?
Not a lot. But some people want to be let-only people, don't you? I mean, you'll be banned from marketing a property until you're on the PRS database. I'll tell you the truth about the PRS database. They want to provide a register of rogue landlords. I don't know how that works with GDPRs and privacy, but we can charge you to register for you or not charge depending on which office. As it's him, you're screwed. But this is really important because local housing authorities and trading standards will have access to this database and they'll be checking you out. And I'm sure sharing information with HMRC. Just a thought.
Is that information also shared with the local council?
Yes, and tenants. The tenant will be able to look up your property address and to get an idea of whether the property is compliant or not. Well, I don't think that's a bad thing, do you? I mean, I'm sure you do things by the book, don't you? Does anyone not do things by the book? It's always a very no answer to that. Has anyone heard of Awaab's Law? That poor little kid who died because of damp and mould. It was an awful case. I will say this, it was social housing. Nearly all of these cases are social housing. It's not you lot. You look after your properties, don't you? But you must be aware of the timelines. So, tenant phones you up and says, I've got damp and mould growing. You have 7 days to commission a report. When you've got the report, you have 14 days to instruct builders. Now, the more experienced landlords here will know how hard it is to work out the source of damp, true? And seldom is it one source. I once had this very nice lady who rented a flat off me on the Isle of Dogs, Lochs Wharf, brand new block at the time. She phoned me up and she said, I'm really sorry, but there's mould all over my bedroom wall. I thought it was brand new, isn't it? We went round with my Dettol mould and mildew remover, got rid of it. A few days later, she phoned, she said, it's coming back. I don't know what to do. I said, don't worry, we're good agents. And we got a dehumidifier and put it in the bathroom. And within a day or two, it was full. So I said to her, is it all right if I go around and empty it? She said, no, of course that's all right, Eric. So I went round, got the dehumidifier, emptied it down the bath. I thought, this isn't right. This is a brand new property. Opened the second bedroom and there were 3 clothes horses full of soaking wet clothes. And I said to her, why don't you open the window to get a bit of ventilation? She said, I'm worried about burglars. You're on the 4th floor, love. The HHSRS is the Health and Safety Rating System. All I will tell you is, I'm not going to go through it, it helps you as landlords. You don't need to be qualified, you just need to be competent. And you can look up on the government website sufficient information that you will be competent. So it's just identifying category 1 and category 2 hazards. Does that make sense? If you do Legionella's risk assessment, you don't need to be qualified, you need to be competent. All right?
So sorry, going to that damp and condensation. So my worry is getting workmen to actually, because there aren't enough workmen to do it. Some of my properties are in the northern region, which are very damp and old buildings and...
Well, the northern region of here?
No, Hull.
Where?
Hull.
Oh.
Hull.
It's pronounced Hull.
Hull.
And you're quite right. This is an issue.
You can't get a workman at all to do anything up there.
It's a bit like EICRs, the electrical safety certificates. I think last year 5,000 were needed. This year it's going to be 25,000. All right. So electricians will be driving Bentleys again. So it's always best to get them done early. In the case where you can't get workmen in, what I would always do is what we call the due diligence defence, and inform the local housing authority that you've had this complaint and this is what you're doing with it. Another example of this is where you get tenants who won't let you have access to do a gas safety check. We get this all the time. What do? You've got to have one by law, but they won't let you in. You can't let yourself in because that's illegal. So what do? Tell the local housing office that this tenant won't let you in, and that is your due diligence defence. Does that make sense?
We have a managed property. Would we have that personally, or would
If you have a managed property, you don't need to worry. It's his problem. So just to sort of skip through this, investigations are changing. Trading standards will be able to go anywhere in the country now, not just within their own local borough. My local trading standards officer, he's a very nice man, I asked him, saying, look, this agent hasn't got his ombudsman certificate, client's money protection. And he said, Eric, I don't care. I'm worried about dodgy vodka and bent MOTs. I don't care about stickers in windows. Whereas my friend Alex, who's head of Newham Trading Standards, when she was stuck in Spain during COVID, was fining agents 150 grand a week just from their websites because she was bored. All right, so they will be able to do anything they like. They'll seek information from any person. They'll have the ability to enter an office without a warrant, seize computers, documentation, and ultimately they can enter the property that they believe is rented. Now, we've had, in my offices, because I don't run the whole of TPFG, I've just got the 6 brand, we've had over 40 trading standards inspections. And my friend Alex said, I'm not going to any more of your offices because they're all fine and I can't fine you. All right? They want to fine because they get to keep the money and they're short of money. Agents' fees will have to change because you won't have, on let-onlys, there will be no more renewal fees. So we're going to redo our terms of business. You may incur a cost if you want us to do your Section 13 notice or represent you at the first tier tribunal, which will be quite technical. And we'll be looking to pretty much focus on our rent collection and managed people. Now, commencement, when is this going to happen? I had a call with government minister today. No, that's not true. A civil servant today. Matthew Penny Cook, that I accidentally called him something similar. He only lives in the road opposite me and he crosses it every time he sees me. He said it would be in by the summer. It won't be. We've got the summer recess to come. They've got some really serious legislation they're trying to get through. I think the earliest it will be after the committee stage, which ends in a couple of weeks. There's 52 pages of amendments. How many do you think will be accepted? None. Because the government's got a 66% majority and it's a manifesto commitment. So the chances of them accepting any amendments, they've put amendments in for student lets, they've put amendments in for fixed term tenancies and amendments for advance rent. They're not going to happen. There are some amendments which will be allowed, but that's just about wording. All right? So the bill is 98% of the way there. Section 21 will end the day it becomes enacted. So we'll get royal assent probably before the summer, and then a transitional period. The earliest it's going to be enacted will be October, but there was talk today, they were all pulling faces on the call saying, it could be January. But it's going to happen. All fixed term tenancies will cease to exist. So even if you've got a tenancy agreement which says for a fixed term of 12 months, no, it ceases to exist. Is that absolutely clear?
Sorry, that's when it's enacted.
When it's enacted, yeah. Not when royal assent is granted, when it actually applies. We wanted a 6-month transitional period because we've got a lot of work to do. But we think it's more likely to be 3 months. And this is, I'm going to just read this to you. This is actually in the legislation. Everything else will be enacted when ready. Because can you imagine how much work's involved in building a database of 4 million landlords? And we know how good government are at IT. So it'll be when ready. And I can tell you something else that you will never have heard anywhere else. There'll be another renters' rights bill in 2028 to fix all the screw-ups they've made to date. They did this with the 2004 Housing Act, which was then amended in 2008 to include deposits, but they can change it by way of secondary legislation. So there you go. Housing Minister wants it in place in the summer. October is the long stop, but I think it might be longer. So just a couple of quick reminders. The great landlord sell-off is a myth. 11% of landlords put their properties on the market for sale. Of that, 40% put them back on for lettings. So it's not as bad as it seems. There are landlords selling, but there's landlords buying as well. We've never had so many investor landlords out there looking to pick up properties. The portfolios are changing. There's more portfolio landlords than single individual landlords, and they're buying. Our Winchester office only deals in investment buyers. But don't just think about the yield. One of my dearest friends, he thinks he's an expert in economics. He thinks he's the Martin Lewis of Chislehurst. And he said to me, Eric, I'm only getting a 4% yield. I said, right, how much did you buy that little house in Nursery Gardens for? 250 grand. What's it worth now? 460. Done well, haven't I? Yeah, shut up. And I mean this, self-managing could prove very expensive. And one thing Lucy is going to do in a sec is explain to you how we can help you. Because I've given you a lot of scary stuff, haven't I? I know that, and I'm sorry. But you need to know the facts. And finally,
I've got one.
right, let's go around the room, yes.
It's not really renters reform, EPC re-rating.
2028 was the initial date.
Right.
But that will only apply to new rentals. Existing rentals will be 2030, and we think all rentals will actually be 2030. So it's another thing governments have screwed up. So,
any observations or thoughts on what this might do for the mortgage market or what lenders make?
I don't think it'll make a blind bit of difference. The mortgage markets are immensely competitive. No one wants to lose out. Anyone else? So,
Can you throw any light on the proposed caps on ground rents?
Yeah, we're going on to the Freehold and Leasehold Reform Act. It's still being debated and going through. I know it's a nightmare. The best resource to look at your leisure is a website called the Leasehold Advisory Service. Have you looked at that?
Yes, a lot of us have had our ground rent increased from 2,350. I'm paying £412 a month in ground rent.
You see, this is criminal. You need a specialist leasehold lawyer, all right, to do a review of your lease, and whose card I happen to have in my pocket. And I'm serious, I'll give it to you. Okay, because she's fantastic, she knows me, and she will give you advice, but all she does is leasehold property. So, oh, he's gone. Madam.
How likely do you think it is that this will be used by government as sort of an extra revenue stream? I mean, do you think they're going to be charging large fees for landlords?
No, I don't. No, because they want people to register. Yeah. I mean, their cause in a few ways is actually noble. All right. I mean, they're doing the right thing just in the wrong way, and they have no idea the consequences some of their actions are going to have on the rental market. But no, it's not about revenue raising. That's what local authorities do with their license. Any more questions, anyone?
We just enacted a section 21 to get our property back so that we can do some major renovations on it. The property hasn't been done for a few years, and we like to keep our properties up to date. How can we do that in the future?
Good question. Under Section 8, I can't remember what ground it is, might be 6, any renovations that will render the property uninhabitable is an automatic right of possession. Okay, so it's actually listed under the Section 8 ground. No, if in the process of doing the works, so you've got to rip the kitchen, the bathroom, take the roof off. Yeah. So you can do that, and there are grounds for that, and then mandatory grounds. Section 8 notice, I think, is ground 6, but it is a mandatory ground.
As renters' right bill, does it affect in any way that the other sort of safety checks, like gas safety checks?
No.
So everything stays the same?
Yes. Everything stays the same. Okay. Right, well, thank you. It's hot up here. I hope that's been useful for you all.
I'm Lucy Mitchell-Abbott. I come from Homelet Let Alliance. We are the partners for Country Properties when it comes to tenant referencing and rent guarantee. And today I'm going to be talking to you a little bit about the products that we offer, how we're going to support you moving forward, how we're going to ultimately protect you during this changing market. We're going to touch a little bit on the legislation, what we've seen in when it comes to arrears historically, and what we're expecting to happen going into the Renters' Rights Bill. Before I do go into the next point, I want to talk to you a little bit about tenant profiling. So Eric touched upon it beautifully there about what we're seeing in this market, the fact that we're seeing the behaviours around landlords. Let's think a little bit of the behaviours around tenants, okay? Now, I'll start with a bit of a memory. It happened a couple of years ago. You'll all remember it. We all went into lockdown, right? Now, when we went into lockdown, our rent guarantee book, so we'll talk a little bit about the sheer size and volume in a second, but our rent guarantee book had a hit of claims, had a massive amount of claims come in. Why do you think that was?
Tenants didn't get paid.
Tenants didn't get paid? Well, they had this beautiful thing called furlough. So they had 80% of their salary coming in. Yes, it was only 8%. Remember, they weren't going to the pub. So surely they should be able to pay their rent. However, what actually happened is there was something called the media. You'll all remember that most mortgage companies allowed you to have something called a mortgage holiday, right? Where you got 3 months, not free, but you've got a 3-month leeway, right? What happened there? Well, the media took that, they put it in the press for tenants to see, and they marketed it in a way that said, your landlord gets a 3-month mortgage holiday, and so you get a 3-month payment holiday. We know the way these things work. So as a result of that, there was a massive influx of claims that came into us because tenants called their agents or landlords and said, we can't afford to pay the rent. Well, actually, it was them utilising the tools they had available to them. And they thought, well, we get 3 months free, so we'll try our luck, okay? It's natural human behaviour. That is not going to change when it comes into the Renters' Rights Bill, okay? tenants are going to be given a lot of empowerment and they will try and use it. So ultimately what we need to do as a supplier is give you the protection to put the right tenants in the properties from inception, but also if things go wrong, and they sometimes do go wrong, that we ensure that you get a return on your investment. So if you've not heard about Homelet and Let Alliance before, we offer tenant references and associated products. Now, we partner with Country Properties and the Property Franchise Group. Why do we partner with them, or why do they partner with us more importantly? Well, our rent guarantee book extends to, anyone want to hazard a guess? There's not going to be prizes, so don't get too excited. Our rent guarantee book extends to £1.5 billion in annualised rent. So it's a massive, massive book. And we do 1 million references a year. Now, the reason that those elements are really important is because we have more scope than most providers on the market. We don't need to use a third-party solicitor. We do everything in-house. We've got our own in-house litigation team, okay? Now, just moving on, we're going to talk a little bit about fraud. So who here has ever created a fake bank statement? I don't have the police one outside. Don't worry, you're not going to get in trouble. Has anybody ever thought about fraud before? I'm just going to play you a quick video. So I'm just going to set the scene, okay? You've got a tenant. They've been in a property for 5-6 years, great tenants, okay? The landlord has decided they're going to sell the property for whatever reason. Section 21, no fault eviction has been served on that tenant. That tenant looks at the open market and thinks, I cannot afford this rent. The rents have gone up massively, but they ultimately have to house their family. So can they rent legitimately? No, they can't. They're going to have to look at illegitimate options. So they're going through the referencing process. They say I earn X, and all they would need to do, go back. All they would need to do is go onto Google, type fraudulent bank statement. Those that have done this will know this far too well, by the way. You can see some come up here. Etsy comes up, which is crazy because I thought that was a craft shop, but anyway. You've got one here called Template Lab. Okay, this is an American site. It's been closed down a load of times, but they could pop up under a different URL. You can see they've got a load of American bank statements here, but if we go further down, you'll see that they've got UK bank statements. Now, I know this one well because I actually have this account. All I would need to do as a tenant to create a fake bank statement is click download. I don't need to put any of my personal information in. I'm not online shopping, that is just pop-ups, by the way. And I can export it into Word. I literally remove the little logo at the top, and I can start amending my information. Simple as that. Does that shock anybody? This is what we are dealing with, and ultimately why Country Properties work with us as a provider. Because we know this is going on, we know this poses a threat to you guys, and we need to ultimately make sure that we are protecting you accordingly when it comes to a threat like this. Now, Homelet and Let Alliance are the first provider in the market, based on the sheer volume and size that we are, that have able to put AI into our referencing. So no other provider out there has that. Okay? So straight away, any documents that come in for a tenant, we can straight away upload that to our AI portal, and it can tell us if it's been amended in any way. Okay? So you can see on this one, not only can we see the original text, but we can see what it's been changed to. So we had one a couple of weeks ago, actually. Looked really great. Had about, I think, 6.5 grand in their bank account. Guess how much they actually had? 12p. Obviously after a night out that weekend, but anyway. These are imperative that we're delivering due diligence like this. It is going to be harder to evict tenants. So actually, it becomes more important of not just doing the basic referencing that's been done for the last 30 years. We need to innovate referencing. We need to do referencing the same way that mortgage lenders do it. We need to use data that's available to us. which takes on to the next step of how we're going to protect you further. We're now the first provider on the market that use the tenant's full credit file to access their credibility financially. So what we're not just doing is contacting the employer and saying, does this person work there? And we could think we're speaking to Sally from HR, but it's actually Susan, that tenant's best friend at work, who's saying that they earn X when they actually earn Y. That's got no credibility anymore. You don't see mortgage lenders calling up your company and asking if you work there. It doesn't happen. We're using accurate data to not only look about what income comes into that tenant's account on a monthly basis, but then we're looking about how much credit they've got associated to their name. It's not just about the money that's going in, it's about the money that's going out. So if they've got credit up to their eyeballs and they don't have enough net income to afford your rent, we're going to know about it and we can tell Country Properties accordingly. And they can lead you in who is the most credible tenant, who can afford it, who has a best relationship financially. So let's circle back to the Renters' Rights Bill. Eric has beautifully articulated all the changes that are happening. Oh no, that's not good, is it?
All right, IT support.
I know, IT support. I'm sure it'll be fine. So, we know tenants are going to be in situ for longer periods. Once they go into arrears, currently they have to be in 2 months of arrears and then you can apply for possession. Serve notice, apply for possession. That is going to be going up. So they're going from 2 to 3 months before you can actually serve a notice. And then that notice period is going from 2 to 4 weeks. Okay. So it's 4 months before you can even do anything. Okay. Now think about what Eric said earlier. If, for example, you've got a tenancy that's executed and that tenant doesn't pay that first month's rent, you still have to give them the keys. So technically, a tenant could be in that property, in a new tenancy, move in, and you wouldn't be able to do anything for 4 months. Okay? We're not saying things like this to scare you. You guys need to have the knowledge of what's going to happen so we can demonstrate how Country Properties are going to be protecting you moving forward. It's imperative. Now, abolishment of Section 21, no-fault evictions. At the moment that we use these, we use them at our disposal where possible because sometimes going on a Section 8 breach of tenancy is hard to prove. It's sometimes done on the judge's discretion. I'll give you an example. Currently, it is law that you can deny pets in the property. There has been a load of times where we've gone to court and the tenant probably has dogs themselves and refuses to render a tenant homeless because they've got dogs. So sometimes it is about the judge on the day. That's why we use sometimes Section 21s because we know it gives us a level of certainty. We won't have that anymore. So we need to make sure the paperwork is every I's dotted and T's crossed to give you the best possible chance of possession. But what we also need to do is deliver a product to you that's going to support you financially in the meantime. If worst case scenario does happen, so you'll continue to get a return on your investment. If we look at the claims statistics, over 2024, it took 7.5 months from the first point of arrears to actually getting vacant possession of the property. Does that figure shock anyone? Now remember, again, circle back to that figure at the start. Our rent guarantee book extends to £1.5 million in annualised rent. So we have a very good depiction of what's going on in the market and what you can expect if things do go wrong. In the last 6 months of last month, it increased to 8 months. Okay? So it is going up. We do know it's going to be going up again. Why? Can't use a Section 21, no-fault eviction, to limit the exposure, to get them out quicker. That's number one. Number two, with a Section 21, no-fault eviction, you don't need a hearing. With a Section 8, you'll need a hearing every time. So because of that, more hearings are going to take place. That is going to mean that there's a backlog in court proceedings. That will affect when you get your court date. Okay? That's number one. Number two is because we can't rely on Section 21 where there are discretionary cases, So when they're not mandatory grounds under Section 8. Previously, we would just use a Section 21 to get it going quicker. Though that can't be used anymore, so there are going to be more discretionary cases going into court, which are going to take longer to conduct. All of these elements are going to mean it's going to take longer to secure a court date. Again, this isn't to scare you. We want to give you the information to what you expect so that we can talk about why there's a need for protection moving forward. Now, a case example. So we'll touch upon the financial loss there. You can see this, and you can see the credibility behind the calculation there because it is worked out based on what our average is, based on the average rent. We had an example, a claims example last year that always sticks in my head. Okay, tenant went into arrears. 2 months of arrears. We served a notice on them. I think it only took about 3 months to get a court date, so not very long in that instance. We went to court, and the tenant turned up on the day and said, I've not had a chance to prepare my defence yet. What do you think the judge's response was to that? If I had prizes of sweets, I'd be throwing them everywhere in it. Yes, absolutely. So they did adjourn it. They said, you should have a right to have a defence. So they said, we'll secure you the next court date. So that was October the 28th last year. When do we think the next court date was? January, February? It still hasn't happened. Bingo. So it's June. Okay. So again, these are the examples that we're seeing more commonly. Eric's spoken about what the changes are going to be with the Renters' Rights Bill. We need to make sure that we're protecting you in 2 areas. One, we do the due diligence at the start. We innovate that process. We make sure it's market leading to give you the best possible chance of getting the best possible tenant in that property. Okay, that's stage number 1 of how we protect you. Stage number 2 is that we give you a service that delivers this type of protection. So if worst case scenario happens, when Country Properties are calling you, they're not calling you to say, unfortunately, the tenant's fallen into arrears, over to you. You've got to find a solicitor. You've got to endure the cost of not going without that rent for that period of time. They want that conversation to be, tenant's gone into arrears, but don't panic. You've got the protection. You're covered. Leave it with us. That's what we want the conversation to be. Now, what does that look like? So the rent protection covers up to 15 months rent arrears. So as I said, at the moment, let's go on that 8.5 month average. You've got more than sufficient cover if those arrears periods do increase. Okay. We'll also support you after you've got vacant possession. So as long as you're actively reletting and looking for a new tenant, we will subsidise you up to 3 months, but at 75% of the rent. So we're continuing that financial support. Okay. We've got professional costs up to 100,000, so things like your legal costs, your bailiffs, things like that. That's included within the policy. But remember, we've got our in-house litigation team. So what will happen with most providers, like your direct lines out there, look really good on paper, but what they do is they outsource all their legal work to somebody cheap. Okay, you will feel the effects of that. You don't have a relationship with them. You will feel the frustration. Okay. We have an in-house litigation team. All they do day in, day out is this type of work. They build up case law. They know trends in this market. So you want to put this type of thing in the hands of someone that you can trust. Again, that's why we work with Country Properties. They've seen what we can deliver to ensure that we're going to get your tenant out as quickly as possible. We're going to financially support you in the interim. Last words. My CEO makes me leave this slide in. I never quote him, but this is Andy Halstead, our CEO. He's talking about, we partner with 5,000 letting agents. We partner with 5,000 letting agents for a reason. And that's because we've got credibility and within our service. We want to bring consumer confidence back to this market. We know the government are making it difficult for you. We know there's a lot of question marks about what to do next. We want to give you the confidence that you will continue to get a return on your investment, and this is how Country Properties will support you in doing that. Any questions?
What's this cost? Your example, you showed a
What the cost of the policy? Well, you can speak to Country Properties directly.
£1,000.
It's priceless. Country Properties are going to be engaging regarding this. So you'll get a full understanding of the service and the cost associated to it.
You mentioned Country Properties, but I'm the letting agent, part of your group, and I recently took out policy that's got Landlord. Is that the same?
So they're a separate referencing company. I have to be very careful because I'm getting the eye from Eric.
I don't.
Sorry?
I don't have to be careful. Yes, so I'll tell you two things about Goodwill. Don't quote me. Number one, they don't like paying out. They don't. They pass it over to the lawyers, underwriters who try not to pay out. And secondly, you wait to see what their new premiums are.
That was the thing, they just took the money out. When I got the rent,
Yep.
they just deducted the money.
So we're not like that.
Yeah, who do you use?
Martin.
Martin & Co. Which branch? Bedford.
So should I?
We'll
Well, they'll be moving over.
they'll be moving over to us anyway.
If you speak to Shahid, who's the principal,
Yeah.
he will transfer it over in due course. It might be the next few.
Yes.
The whole group's moving over.
Okay.
Yeah.
That's how we got these unbelievable prices.
You caught me on a good day. Any other gentleman at the back there?
Hi. Just GDPR allow mark on bad mark follow back.
Really good question. So what we have is something called an internal default database and an internal fraud database. So we can't, if for example we think somebody is potentially fraudulent, we will share that with CIFAS, which is the lead fraud prevention agency. So we will share that within their database. Not every referencing company is part of CIFAS, but again, we do 1 million references a year. So the likeliness of referencing will come with us is quite high. So that protects you guys from it flagging of potential fraudulent tenants when you're undergoing new tenancies, but also flags to other agencies if there's a risk of historic. And then if we've got a property with a rent guarantee on, the tenant goes into arrears, a claim is made, and they have left, for example, an outstanding amount, then that will flag on our referencing as well. So if they've tried to go from a different property where there's an outstanding rent, the likeliness if we've got a policy on it, that will flag when it's going through for referencing as a potential tenant for you.
That go through, is that the same for tenants on benefits? Full benefits?
Full benefits. So we will look at them.
If the council pay them, and then they pay the agent, and then they take the money, obviously there's a period of time before the council will then support, pay directly to the agent or the landlord. Will those cover those ones where the benefits are in arrears?
Yeah, well,
they don't pay.
So the criteria that we have at the moment is as long as they're not in arrears, that we will put them on cover for the purpose of this at this point. And that's only based on your relationship with Country Properties. We wouldn't do that with any other client. If it's somebody that is in arrears currently, for the insurer, that poses quite a lot of a risk, as you can probably imagine. It's like trying to take out house insurance when your house is on fire. It's quite a big risk for them. So those ones we can look at in their own entirety. What we'll do, we've got an in-house underwriting team. They will assess the rent schedule, look at the risk and see if cover can be offered. So as I said, go to Country Properties. They'll give the example to me and I can have a look if we can wangle something, if there is a scenario like that.
So you don't really like doing benefits?
No, it's not benefits. It's just sometimes it's hard when you, like, for example, apply for a hearing and they keep coming in and out of arrears. So from an insurer's perspective, we would ask that we would submit a claim within 31 days of the arrears. They keep coming in and out of the arrears. It's hard for the policy to perform as it should. So we're FCA regulated, so we need to make sure the policy acts as it should. So it's just making sure that we've done our due diligence to make sure the policy is going to act as it should for you.
Yeah, because that's one problem I do have is tenant who starts, because they know exactly how many months before, and then they start and it resets the clock and you're forever.
I would be interested to look at your rent schedule to get an understanding of the behaviours, and I'd be able to go from there if you're happy with that.
stuff that we pay in policy, then guarantee for the maximum of 3 months. I didn't realise that. Is that kind of standard with all policies? Guarantee?
So we pay up to 15 months rent arrears or until vacant possession, which is ever sooner. But what we have is an additional benefit on with it, which is the 3-month vacant possession, which is an additional benefit because obviously it's not contracted rent once the tenant has been evicted. So what idea is we're trying to support you during the transition of appointing another tenant. The only condition of that, it has to be actively remarketed. But yes, you can get up to 3 months or until you get a new tenant.
Policy covers up to 100,000 in legal fees. That's what's the sort of average cost? Depends. I know it must vary, but how much does that cover?
It does vary. To give you an idea, we've got our own in-house litigation team, so we can do everything at cost rather than going to these outsource to these solicitors that inflate their prices. So we're not really even getting to 50% of that a lot of the time. So rest assured, if it was going over that, we wouldn't be able to fulfill our obligation. We would be talking about lifting it, but we don't need to. But great question. Never been asked that before.